The next item of business is Stage 3 proceedings on the UK withdrawal from the European Union Legal Continuity Scotland Bill. In dealing with the amendments, members should have the bill as amended at Stage 2, the marshalled list and revised supplement to the marshalled list, and the groupings. The division bell will sound and proceedings will be suspended for 5 minutes after the first vote of the afternoon. The period of voting for the first division will be 30 seconds. Thereafter, there will be a voting period of 1 minute for the first vote in a group. Members who wish to speak in any debate on any group of amendments should press their request to speak buttons as soon as possible after I call that group. We now refer to the marshalled list, and I call Amendment 14 in the name of Adam Tomkins, grouped with Amendments 14A and 49. Adam Tomkins to move Amendment 14 and speak to all amendments in the group.
Thank you, Presiding Officer. I move Amendment 14 in my name. Presiding Officer, it is imperative that Brexit, that's to say the United Kingdom's withdrawal from the European Union, does not inadvertently undermine the integrity of the United Kingdom as a union of 4 constituent nations. Indeed, Brexit should deepen and strengthen our precious union. The United Kingdom common frameworks that we know that we are going to need in areas such as agricultural support, public procurement, environmental protection and the like will, if they are designed properly, lead to a new post-Brexit era of shared government in the United Kingdom, with the United Kingdom government and the devolved administrations working together in the common interests of all of the nations of the UK. That is exactly as it should be. Now, we know that the Scottish Parliament and the Welsh Assembly are going to become even more powerful as a direct result of Brexit. A whole suite of powers, all of which, by the way, the SNP Green Alliance would rather say no to and would rather hold in Brussels, will be coming here. These include, but are in no sense restricted to, aviation, carbon capture, marine environment, maritime, energy, including renewable energy, flood risk, water quality, forestry, cross-border healthcare, roads, transport, voting rights, and many others. Presiding Officer, my amendment seeks to ensure that the operation of these new powers does nothing to undermine, impede, or restrict the operation of the United Kingdom domestic market as it operates now. And those last words are important. This amendment imposes no new restriction on either the Scottish Parliament or Scottish ministers. This amendment takes nothing away from either our legislative competence or from ministers' executive competence. My amendment seeks to define and understand our precious union, or the domestic market broadly. Of course, commerce and trade are at the heart of it. The free movement of goods, capital, services and labour. Free trade was the reason why the Union was established 311 years ago in 1707, and it is the reason why Scotland has prospered in the 3 centuries since. But it's not just about trade. Our union is a social and cultural union too, and again, my amendment recognises this and seeks to protect all of that. Presiding Officer, Scottish Conservative amendments at Stage 2 tried in a variety of ways to protect the union, by making this bill subject to the European Union Withdrawal Act, for example, or by making it subject to the Scotland Act, or both. Now, we fully expected the SNP Green Alliance to vote these amendments down, as they will presumably seek to vote this one down today. That's par for the course. They don't believe in the union. They want to terminate it. But the Scottish Labour Party voted with the SNP Green Alliance at Stage 2 to defeat our union-protecting amendments. Labour didn't want this bill to be subject to the Scotland Act. They voted against that proposition. They didn't want this bill to be subject to UK legislation on Brexit. They voted against that proposition. They wanted exactly what the SNP want, namely for this bill to give the nationalists licence to use Brexit as an excuse for undermining the union, chiselling away, bit by bit, at Scotland's rightful place at the heart of the United Kingdom. Labour's amendment today to my amendment, Amendment 14A, in the name of Neil Findlay, a member of the Parliament who couldn't even be bothered to turn up for any of the Stage 2 debates, reinforces our view that the Scottish Labour Party is increasingly untrustworthy on the union. Mr Findlay's amendment time limits the requirement to act compatibly with the UK's domestic market to 6 months, or to the coming into force of a common framework, whichever is earlier. This hands the SNP a veto, Presiding Officer, with no checks and no balances. All they have to do is to hold out for 6 months, refusing to sign up to any UK common framework, and thereafter they are free to act in any way they like, quite regardless of the UK's legitimate interests in preserving its market integrity. For a nationalist, no problem. But what a so-called party of the Union is doing, putting such a reckless proposition to the Scottish Parliament, I have no idea, and we will not be supporting it. Finally, Presiding Officer, Mr Finlay gets to speak in this debate, and I look forward to hearing how he's going to justify, one, his refusal to turn up at stage 2, and 2, his amendment to my amendment, and I'll respond to his points when I sum up. Finally, Presiding Officer, in this group is Amendment 49 in the name of Tavish Scott, and we will be supporting this amendment. The power to keep pace with European law post-Brexit, provided for in Section 13 of this bill, is an extraordinary power. Indeed, it is an extraordinary power grab by Scottish ministers, and Tavish Scott's Amendment 49 is an important and valuable constraint on its exercise. So I commend the amendment in my name and the amendment in Tavish Scott's name, both of which we will be voting for, but we will not be supporting Labour's attempt to shore up the nationalist ambitions to use Brexit to undermine the integrity of the United Kingdom.
Thank you. Neil Findlay to move Amendment 14A and speak to all amendments in the group.
Presiding Officer, I wonder if before I move the amendment, if I could ask the Minister to take a few minutes to advise Parliament what his intentions are should Clause 11 of the EU withdrawal bill be amended in the House of Lords, and the Government then has to bring forward legislation here to repeal this bill. What happens to all of the amendments on the environment, animal rights, human rights, etc., the protections that we've put in? Will there be another process for us to incorporate these into law, or will they be cast aside in a process that to many people may have looked like a political game and a waste of time? I think it's incumbent on the Cabinet Secretary to advise Parliament both now and all members of this Parliament in writing what would happen in that scenario. And finally, how will this Parliament scrutinise any deal that may come forward between the Scottish and UK governments, and indeed the Welsh Government, so that we can examine this in this Parliament?
I'm happy to say to Mr Finlay that I recognise the importance of the point that he is raising. There are elements in this bill, for example, the protections on environment, the Charter of Fundamental Rights, the issues in employment that Labour has brought forward, which are different from the EU withdrawal bill in the UK and may require, if those circumstances prevail, to have further legislation. I commit myself to two things. One is to consultation with other parties on how we can protect those if we reach those circumstances. And if the member will also write to me about that, then I will expand upon that to try and find the areas in the bill in which we can find agreement on that, and ensure that in the event, and it may no means a certain event, in the event that the bill does not proceed because of an agreement with the UK, we're able to provide those protections, which are extremely important. And Alan Miller, for example, Professor Alan Miller indicated earlier this week that he thought the Charter of Fundamental Rights and the position we were taking here was a far better position, as is stuff on environment and other things. So I will commit myself to consulting with parties, I'll commit myself to responding to the member, and I'll commit myself to finding a way to do so, should we require to do so.
Neil Findlay.
Presiding Officer, I also asked the Minister about scrutiny of any deal that is brought forward, and how does he intend to provide Parliament with that opportunity also?
I have previously said that we will provide that opportunity for scrutiny of any deal. Nothing will be agreed unless this chamber will agree to it.
Neil Findlay.
Okay, thanks, Presiding Officer. 14A, this amendment seeks to amend the Tory Wrecking Amendment. It's our view that any Brexit legislation must take account of and meet the needs of the different nations and regions of the UK in respect to devolution settlement. As such, it is of great importance that any steps to protect the UK's domestic market are not seen as being at the expense of devolution or incompatible with it. 14 is unacceptable for two reasons. It places no time limit on the restrictions being proposed and seeks to make the restrictions exclusive to Scotland's government. It is in the interests of both the rest of the UK and Scotland that equality is achieved between the regions of the UK in regards to this process, and I propose my amendment as a means to address that and ensure that reciprocal arrangements are put in place. We must ensure that other governments within the UK have an equivalent commitment that will last until common frameworks are agreed. After this point, they would no longer be necessary. This process would ensure the intent of Amendment 14 whilst making it effective and in line with the spirit of devolution. If the Tory amendment was passed, then policy innovation may be curtailed, as any Scottish Government would be prevented from deviating from practices elsewhere in the UK, practices that are deemed to distort the UK market. For example, we could not introduce public health levies. We couldn't introduce the smoking ban, the plastic bag tax. This would go against the spirit of devolution and the interests of our people and our democracy. We will also not be supporting Tavish Scott Amendment as we believe the existing wording is more appropriate. Thank you. If you want.
Adam Tomkins.
Mr Finlay, I think, has missed the point of the Amendment 14 in my name, which is that it protects the domestic market as it operates before exit day. All of the examples he gave are examples of devolution that worked before exit day, and they would continue to work with devolution after exit day. You just don't understand the amendment in front of you.
I absolutely do understand the amendment. But what Mr Tomkins doesn't understand is that any of those initiatives could not happen in the future. Similar initiatives couldn't happen. Mr Tomkins, when he was in one of the other many political parties that he's been in over the peace, I'm sure agreed with devolution during those times. But now he's in the Tory party, he just does what his paymasters tell him.
I think we can try and keep the discussion to the issues at hand rather than individuals. Tavish Scott, to speak to Amendment 49 and others in the group.
I sense there's more politics today than there was last week in Stage 2, Presiding Officer. I move 49 in this group. The continued operation of the UK single market is important to businesses and individuals in Scotland after exit day. New powers are being allocated around the administrations of the UK. Extensive order-making powers are being proposed for ministers in all of those administrations. And in many cases, there are the same powers being exercised in 4 different places at the same time. Every party in this chamber believes there should be UK frameworks. The Scottish Government is constantly appalled that it has not been consulted properly. So my amendment today encourages Parliament to make sure that Scottish ministers lead by that very example, that ministers consider the impact of their proposals on the operation of the UK single market. This amendment will be the way to get reference to the importance of that market onto the face of the bill. At Stage 2, Adam Tomkins moved amendments to create protected fields where the UK Minister would have the power of veto on Scottish ministerial action. Well, that put the UK Minister as judge, jury and executioner on policy areas that everyone agrees should be part of a UK-wide framework. I would argue that if the 4 administrations are cooperating, then it shouldn't be for one of them acting alone, in this case, just UK ministers, to veto proposals. Now, if the intention of Adam Tomkins today is to protect the operation of the UK single market, then it is a natural extension to support Neil Finlay's further amendment that makes it clear that all 4 administrations should be given equivalent and reciprocal commitments. Now, Parliament has a lot of time for Adam Tomkins and his background and knowledge as a professor of constitutional law. I certainly too. But today he seeks to insert a section into a bill before even the introductory section which sets out the purpose of the bill itself. That strikes me as pretty close to parliamentary showboating. Mr Tomkins is a serious lawmaker, but he should not move an amendment such as this in this area, and I move 49 on that basis.
Apology, I said we wouldn't be supporting this amendment. We will be supporting that one.
Thank you, Mr Finlay. I call Bruce Crawford to be followed by Patrick Harvey. Bruce Crawford.
Thank you, Presiding Officer. After last week's 11 hours, I hadn't really intended to speak in this debate, but having sat down and read more closely Adam Tomkins' amendment, I thought I really had to get to my feet and make a few points. Now, normally Adam Tomkins knows I fully respect his position in regards to the way he makes an argument and puts across his point. We work very closely together on issues around Clause 11. But I believe his amendment today is an attempt to put this Scottish Government and any future Scottish Government in a policy box and restrict its choices. Now, it might not be that he means that, but if you look at, in particular, 3A in his amendment, it's a very wide power and open to very wide interpretation. For the purposes of this Act, the exercise of any power is to impede or obstruct the United Kingdom domestic market, but is not limited to and making of any enactment. Now, that's a very wide power to give any future UK government. But it gets worse. That would result in any unregulated divergence materially damaging to the ability of individuals, corporations, entities based in Scotland to trade or contract, etc. That's a very wide power. Yes, surely?
Adam Tomkins.
Very grateful to Mr Crawford for his forgiving way and indeed for his kind words. This bill is called a continuity bill. The opening words of my amendment, as Mr Crawford will have noticed, are to seek to preserve the operation of the domestic market in the United Kingdom post-Brexit as it operates now pre-Brexit, so that there is continuity between the situation now and the situation in the future. No more, no less. There is no greater ambition in this amendment than that. It is fully consistent with the purposes of the alleged purposes of this legislation, which are to provide for continuity. Will Mr Crawford not accept that?
Bruce Crawford.
I take Adam Tomkins at his word, because that's the sort of guy I am. But actually, I think Neil Findlay, I don't often agree with Neil Findlay. I don't think I've ever agreed with him before, actually. But on this one, Neil Findlay's right. This is not just about what's gone before, it's also about what this place can do in future. And had we had not in place the minimum pricing, no smoking legislations, changes to future income tax even rates, which the Tories argue that in some way would undermine Scotland, undermines our relationship with the rest of the United Kingdom right now, that before we even have this legislation, differential support in agriculture, which already exists but probably couldn't exist in future if this amendment were to pass. Business rates. Can we set different business rates which should impact differently from the rest of the UK? Landfill tax, which may be different. We've chosen not to at this stage, but we may in future choose to make it a different level. Or the land and buildings transit tax. That could well be diverted from in the future. These are all areas where the Tories have argued that these policies are damaging to Scotland and damaging to the internal market. And potentially, in future, if we do leave the European Union, I hope we don't, but if we do, in these circumstances, there may well be an argument that Scotland should have power in future over VAT, because it's only the European Union legislation that stops us having power over that VAT. So if Scotland was to decide to have a different rate on VAT to the rest of the UK, potentially this amendment would undermine this Parliament's ability to do that. So I understand Adam Tomkins' ability. He wants to stop undermining the UK internal market. I think he's flawed in that argument, but I believe his amendment either inadvertently or deliberately undermines the devolution settlement. Now, Adam's good, very good. Tomkins is very good and plausible at putting across his arguments, but I think on this amendment he has been. Yes, I'll give way.
Neil Findlay.
Just wonder what the Tory argument would be if this was in relation to local government and they tried to restrict it. They'd be the first people saying that centralisation of power.
Bruce Crawford.
Come May this year, I'll have been elected for 30 years. I know I'm beginning to look like it in one way or another. And I've seen a lot of vault faces from the Tories, particularly in local government, and the way they stand up for local government now, and the fig leaf they put around themselves in that is in stark contrast to the past way they have behaved as far as local government is concerned. But I believe that Adam Tomkins is always very good at sounding plausible. But his amendment, I think, on this occasion, he's been found out, and I would encourage the Chamber to vote against it.
Patrick Harvey, to be followed by Peter Chapman. Patrick Harvey.
Thank you, Presiding Officer. There's a phrase, an accusation, which is sometimes levelled at those of us who support the idea of Scottish independence. But I think on this occasion, it's Adam Tomkins who needs this accusation levelled at him. He's stoking constitutional grudge and grievance. I think that's the basis of what he's trying to do with his amendments. I can't support any of the amendments in this group, Presiding Officer. I want to address, first of all, of the lot of them, the most reasonable, at least at the surface level, is that comes from Tavish Scott, about an assessment, a statement making an assessment of the impact of a draft instrument on the operation of the single market. I do think we need some kind of clarity about whether we talk about a single market, an internal market, a domestic market, or what that language really represents. But it might be thought reasonable that an assessment be made about the impact of a draft instrument. But the implication even of that is that it is the Scottish position, the position proposed by a Scottish government and endorsed presumably by a Scottish Parliament, that would create regulatory divergence. If regulatory divergence takes place, It is the result of multiple positions which are not all the same. To blame one aspect of that rather than the other, to say that divergence, if it happens, is because of a Scottish instrument instead of a UK instrument applying elsewhere, I just think it's an unrealistic assessment to make, to say that a Scottish draft instrument is entirely responsible, or what proportion of the divergence is accountable to the Scottish instrument as opposed to the other measures elsewhere. Give way.
Tavish Scott.
I think Mr Harvey makes an entirely fair point, which is why the amendment we look at involve all the administrations and governments of the United Kingdom to deal with exactly the point he's just making.
Patrick Harvey.
Well, Amendment 49 merely places an expectation on Scottish ministers to make a statement on their assessment of the impact of their draft instrument. Well, I still think that Scottish ministers, in fulfilling that obligation, will find it an impossible task to disentangle what proportion of any divergence is a result of actions being taken in Scotland. Fundamentally, the argument goes deeper, though, with the first two amendments, and in particular with Adam Tomkins' amendment. I think all of us accept that common frameworks will be necessary in some areas, whether in respect of current devolution, post-Brexit devolution, if indeed that happens, or even if we were one day, oh happy day, developing the same relationship with our neighbours that other independent countries have with one another. Common frameworks would probably still be necessary, but common frameworks must be based on consent, and consent must be active, it must be entirely voluntary, and it can be withdrawn at any time. To pass legislation which restricts our ability to withdraw consent to a common framework would be entirely at odds with that basic principle, and it's a principle that I think those of us who support independence should be concerned about. It's also a principle that I think those of us who believe in the Union, in the strengthening and preservation of that union, should also be concerned about. Because if there is going to be any approach at delivering genuine common frameworks with genuine consent and assent and affirmation on all sides, then I think Adam Tomkins is going the wrong way about it.
Thank you. I call on Peter Chapman to be followed by Joanne Lamont. Peter Chapman.
Thank you, Presiding Officer, and I will be brief, and I will declare an interest as a farmer, because my example is about farming. To be honest, I can't understand why any member of this chamber could possibly vote against this amendment in the name of Adam Tomkins. I also support Tavish Scott in his Amendment 49. And in my particular industry, namely farming, the UK single market is absolutely vital to our farmers. Just to give you one example, we export over 80% of our beef, and 90% of that goes to England, and it receives a premium in that market. And any restrictions on this trade would be disastrous for our farmers. Now, farmers are only one example. All Scottish trade depends to a large extent on the single UK market. So it's equally important for all our traders that the single UK market is protected. And I would therefore expect wide support for this amendment in Adam Tomkins' name.
And Joanne Lamont.
Thank you very much, Presiding Officer. I just want to make two brief points. Obviously, like everybody else, I was aware of the briefing done around this particular amendment. And like many other people in this chamber, I have full respect for Professor Tomkins. I have to say that I found his contribution utterly depressing. I thought it served his party rather than serving the serious debate that we're having in the chamber just now. And the idea that the problem that we have to wrestle with just now is whether Neil Findlay attends a committee meeting or not is not appropriate. I would say to Professor Tomkins and to other people who are considering supporting this amendment, the biggest strength for the United Kingdom is that the people of Scotland see their friends across the borders as people they wish to work with, cooperate with, and they don't see them as folk that they want to separate from. That is the strength of the United Kingdom, is when the people of Scotland see in that United Kingdom that they are stronger and not weaker. And so I wouldn't see that we should see this as some kind of litmus test as a commitment to the United Kingdom. The second point I want to make is really to ask further to the comments made by Neil Findlay to the Minister, and I appreciate we are dealing with stage 3 amendments, but I'd be grateful if he responded to this. It took us 2 years in this Parliament to repeal the Offensive Behaviour at Football Act. The plan seems to be that if we can get a deal with the UK government, we will repeal this legislation right away. I think that undermines the integrity and the work that has been done on this bill over the last few weeks. So I would look for a commitment from the Minister, first of all, that he is already in discussions with the parliamentary authorities and party leaders about the scenario where a deal is reached. First, to ensure there is full scrutiny of what that deal is. And secondly, there is a full and detailed opportunity by the committees of this Parliament to look at how this bill has changed the landscape, because it is no longer where we were at the beginning of this process when emergency legislation was first mooted. I think it's about the credibility of this Parliament, that we don't take weeks. We give people huge amounts of work to do, to look at amendments and produce legislation, only to turn round after a statement from the Minister and say that's okay, we will repeal the legislation. I'd be grateful if you could indicate, while he's summing up on the amendment, what his plans are to take that forward.
Thank you. And I call the Minister, Michael Russell.
Thank you. Can I address that point immediately, because I have addressed it with Neil Findlay, but I'm happy to do so with Joanne Lamont. I do appreciate, and I will talk about this later, the work that has been done in scrutinising this legislation, and the work of all parties, and I say all parties, has improved this legislation, and that will be clear this afternoon, when it is clear how many amendments from all sides of the chamber we have accepted to approve the legislation. And quite clearly there would need to be scrutiny in circumstances in which the government were to come to this chamber and to say under this bill, and there's a provision in this bill, which again has been changed during the process, to say that we do not wish to proceed with it. The second point is, yes, I accept this bill has changed the landscape. I hope it's done it positively, because we've pointed to, for example, areas in which there needs to be change and divergence. For example, in the protection of environmental principles, which we've moved forward as a result of hard work from a number of members, and I pay tribute to them, including Claudia Beamish and Tavish Scott and Mark Ruskell. They've all been involved in that process. Issues on protection and reporting and employment and rights issues, which Neil Bibby and James Kelly and Neil Findlay have been engaged with. Later, we will consider an amendment under health, which Anna Sarwar has been engaged with. So there have been areas in which we've improved, issues we've raised, and I give the same commitment I gave to Neil Findlay. We'll come back to this chamber, we'll discuss with the other parties, we'll see the ways in which we can take those things forward. And I'm happy to do so in response to Neil Findlay agreed to write to me on this issue, and I'll sit down with him and talk these things through. Let me, and we'll come back to the chamber with recommendations. Let me deal with these amendments. I have to say that these amendments are thought-provoking. However, I think in the case of Professor Tomkins, the thoughts they provoke are not entirely positive ones. I do have to say that the idea that Mr Findlay and I would unite happily as the bogies in favour of independence is so unlikely as to be the work of fantasy, and I don't often fantasise about Mr Findlay. So, well, indeed, and I hope that first time does not arrive. But in these circumstances, that is a ludicrous argument. This amendment is also, and I think it's important to say this because this amendment comes from a professor of constitutional law, this amendment is littered with undefined and imprecise concepts. And you ask yourself why that would be, why a professor of constitutional law would come to this chamber with an amendment that cannot possibly operate. Could it possibly be because he wants this amendment to be a blockage to the operation of this bill? I simply ask the question. The meaning, for example, of single market, which appears in the heading, but not in the body of the amendment, would be contested. There is a precise meaning for the EU single market. There is no definition of the meaning for a UK single market, because indeed it's not the right term. There is a market, an internal market, but it's not a single market within the European definition. Do we want the lawfulness of regulations to be dependent, to take another example, of whether a court considers that they impede, and I quote, cultural activity and behaviour? I'm sure not even my distinguished friend, the Culture Secretary, would endeavour to define that in a way that courts would be happy with. So this is imprecise language. But actually, the intention is precise enough. Because if this is, as it may well be, the manifesto for making Ruth Davidson the First Minister in 2021, it's absolutely clear what the Tories want to do. The Tories want to make every action of this chamber subject to a decision by the UK government. Every action of this chamber. If that is the manifesto, then I think the only thing that Ruth Davidson will go on winning is a Great British Bake Off. Now, this amendment is also unnecessary, since, as Tavish Scott indicated, every party in this chamber, including the Scottish Government, is seeking the agreement on frameworks that would support the highly integrated markets that exist across the UK. And Mr Harvey is right. Even in the case of independence, there will be a requirement and a need to have frameworks operating so that we move forward in a way that is productive for all of us. This is one of the principles we agreed with the UK and Welsh governments since we began discussing these frameworks. And there is regrettably only one, let me just finish this point, there is regrettably only one government in these islands seeking to separate itself from a single market, and it's not this one. I give way.
Patrick Harvey.
The Minister alludes to the point I was about to make. Does he agree that if we were eventually to be embarked upon a course to independence, we would in no way wish to impede the freedom of movement of people throughout these islands in the way that those in the UK government wish to impede freedom of movement throughout Europe?
Minister.
I entirely agree with that, because freedom of movement is not only productive and helpful, it's essential for a whole range of the sectors within Scotland, and impeding freedom of movement in that way will be very destructive. Now, let me turn to Mr Finlay's amendment. I think it's made in the right spirit. It agrees with the issues of equity, which is important. And it's very tempted to have the opportunity to vote twice against the Tory amendment, once to support Mr Finlay and once to vote against the whole thing. But I have to say, that temptation, but I'm not going to recommend it to the Chamber. This bill isn't the place to resolve the questions facing these islands about the complexities of governance after Brexit, should it take place. The place to resolve those questions is at the negotiating table between governments, and in putting those agreements to the parliaments across the UK. Last year, the Welsh Government, I missed that point from Mr Finlay, I'll take an intervention.
The Minister says that without any hint of irony whatsoever. We want you to get back to the negotiating table and get things sorted out, so get there.
Minister Michael Russell.
At the negotiating table, as does his friend and colleague Mark Drakeford, and I'm very happy to do so again, because I was about to say that last August, the Welsh Government put forward a set of proposals in terms of adjusting the governance in these islands. They came up with new ideas. I was very enthusiastic about those should be discussed. I have to say nothing has happened. And indeed, I want to mention this afternoon in the House of Lords, there is a consideration of the devolution clauses in the withdrawal bill. And there's an amendment from Lord Mackay of Clashfern, who I have to say I've had the great privilege of discussing these issues with in recent days. And I know he will also say the same in the House of Lords this afternoon. I don't agree with his amendments entirely, but he too is tackling the issue of how there should be different relationships and whether there should be some sort of Council of Ministers for the Isles. So even distinguished, thoughtful Tories, real experts in the matters of constitutional politics, are looking at how those things should be adjusted. So I can't recommend supporting either the amendment from Professor Tomkins, nor, unfortunately, the one from Mr Finlay. In any event, this bill is actually about what happens, what needs to happen, if we can't come to an agreement. I've been clear from the beginning, we will seek its repeal. If we come to an agreement approved by this chamber, and I make that point, provision in the bill could never bring about that agreement. Now, finally, let me turn to Tavish Scott's amendment. How could we be tied in the use of our powers in the bill to that concept of the single market in goods and services in the UK if there is no definition of the single market in goods and services? And in any case, there is already divergence. For example, if we look at ending the minimum price for alcohol, there is a divergence. And if you were to apply a definition of the single market as it appears to exist, though it doesn't exist in the UK, but if you were to apply it, then we would already be in breach of that in some of the issues. And indeed, when we come to issues such as environmental protection later, in issues such as employment protection, then we would find ourselves in considerable trouble. So I have to say I understand what he's trying to do, but I think it will unfortunately not be possible to do it. And I say that somebody who admires the way in which amendments from Tavish Scott have actually had a greater rate of success, I think, than almost any set of amendments at stage 2. But on this occasion, I cannot accept that. Presiding Officer, this bill is about asserting the Parliament's right to legislate. At the heart of the amendment from Adam Tomkins is abdicating this Parliament's right to legislate. We can't support it now, and we would never support that. I therefore recommend the Chamber votes against the amendments in this group.
And I call on Adam Tomkins to wind up on Amendment 14.
Thank you, Presiding Officer. I think it's important to start with an understanding of why it's important to protect the Union going forward post-Brexit. It's important not only for the United Kingdom, it's important for Scotland. Scotland trades more than 4 times as much with the rest of the UK as it does with the whole of the EU. The Labour Party sometimes talks about having a jobs-first Brexit. Well, more than 4 times as many jobs in Scotland's economy depend on trade with the rest of the United Kingdom than depend on trade with the whole of the European Union. So that is why it is imperative, it is essential, that right at the top of the Brexit process, we in Scotland combine together to protect Scotland's rightful place at the heart of the United Kingdom, at the heart of the Union. And that is what this amendment seeks to do. No more and no less. And yes, of course, it's in general terms. That's why it belongs at the beginning of an Act of Parliament rather than buried somewhere in the middle of it. I mean, it's criticised by some people for putting this amendment too soon in the bill and criticised by others for not putting it soon enough. It is a continuity bill, and it's a continuity provision in a continuity bill. I notice that Mr Crawford was completely incapable, or perhaps unwilling, to respond to my rather elementary point, I thought, that this is a provision that will change nothing. It was a provision that will simply safeguard that which needs to be safeguarded after Brexit. There is no element of this amendment that would make impossible or unlawful or illegal or difficult any kind of smoking ban, any kind of differentiated tax rates between Scotland and the rest of the United Kingdom if the amendment is read and understood in good faith. But not all of the contributors, I think, have sought to read it in that light. I thought Mr Finley's contribution, Presiding Officer, was absolutely extraordinary for 2 reasons. One, he said that he couldn't support this amendment because it focused on Scottish ministers. This whole bill focuses on Scottish ministers. That's entirely its problem. It's an act of the Scottish Parliament that empowers Scottish ministers, not ministers of the Crown, not Welsh ministers, nobody in Northern Ireland, but just Scottish ministers to do any number of huge and extraordinary things post-Brexit, none of which we should be permitting. And the other extraordinary thing which Mr Finley said was he wanted to put a time limit on the extent to which this Parliament protects the Union. I don't want to put a time limit on the extent to which this Parliament wants to protect the Union. The Union has endured for 3 centuries and it should endure for 3 more. I don't want to put a clock on that. It's extraordinary that Mr Finley, representing the Scottish Labour Party, wants to time limit the protection that this Parliament gives to the Union.
And I call on Neil Findlay to wind up on Amendment 14A. Neil Findlay to wind up. If you want to wind up, Mr.
Presiding Officer, I have nothing to add, and I think we made our position very clear. I think Mr Tomkins' speech, both speeches have been, I think they've shown him up for what he is. He's clearly just someone who takes his orders from the Prime Minister's office, has nothing to add.
Okay, Mr. Findlay.
The Tories trying to depict themselves as the champions of devolution have been shown up today and shown up for everything that they are.
Thank you. We will... the question for actually Mr Findlay, pressing 14A. You are. So the question is that Amendment 14A be agreed to. Are we all agreed? No. We're not agreed. We'll move to a vote, but because this is the first vote of the day, there'll be a 5-minute suspension to allow members to make sure they're in the chamber. So a 5-minute suspension.